CPI, that stands for Child Protection in Iowa. Yes, sounds like I have more of a network quality voice. That's because I've got somewhat of a cold.
Sound like
And
Walter Cronkite.
Walter Cronkite voice.
There you go.
So they tell me that, back in broadcast school, the broadcasters would be kind of proud of themselves when they got a cold because their voice would drop down an octave or two. And but I would prefer to use my own voice than to have to struggle with a cold and maybe not sound as much network quality. Well, the CPI report has a lot of things to think about during this General Assembly. There's a number of things. In fact, there's if you've been watching this program, you've heard us talk about something like 64 different suggestions that the homeschool legal defense people have come up with. Because generally, I thought the laws were fairly good. However, even though the law may be fairly adequate in its construction and its original intent, we find that there are some significant difficulties with the law in making certain that it's carried out in the fashion that the General Assembly intended for it to be carried out. For an example, you may hear us talk about the fact that the rights of a 10-year-old child can be blocked. That is, the termination of parental rights can be blocked by a 10-year-old child if he so chooses. The only problem is, how do you make certain that every child, first of all, is highly skilled in filing the right motions to make certain that that happens? So even though you have a law that sounds good, there are oftentimes problems that arise simply because the right parts or the right elements of that law are not in place to assure that it is enforced in the fashion in which it was enrolled in the first place. Well, I don't know exactly how you'd write every law so as to do that. We generally think that we place our confidence in the hands of law enforcement and others to do the right thing, because you cannot construct a law that will cover every possible foreseeable and unforeseeable circumstance. So it takes the conscious, legitimate efforts of those who are to enforce it to do it properly within the state constitution and within the provisions of the United States Constitution, and sometimes just within the scope of good basic common sense. And for some reason, we have a terrible time dealing with such things as common sense. Don, you've been looking over a story from Arizona, and while we can't go through the whole 12-page ruling, it looks as though at least they're coming partway to some success in handling a case that is being filed in federal court because of the devastation that's come upon a family. Would you tell us a little more about that, Don?
Okay. At least the devastation is not ongoing at this point in time from the DHS, but they caused the DHS the devastation in the first place. The article here starts out, actually it's a court order in the United States District Court for the District of Arizona. The defendants are John Loudermilk and Tiffany Loudermilk, they're the parents, versus Joseph, I'm not sure if I can pronounce the sheriff's name, from Arizona, Joseph Arpaio, Arpaio. Anyway, he's been in the news for the last 2 years. Anyway, I've received emails and different things. This is a hardcore sheriff down there that gets these prisoners, and he believes because they've been found guilty that they should pay their way. So he puts them on chain gangs, and I understand both the men and women are on chain gangs, and some people complain about mostly the prisoners complain about the harsh treatment, poor food, having to work out in the hot 120 plus degree heat during the summer, and just seemingly without mercy. The sheriff doesn't care. They're found guilty, so they deserve the punishment, is his idea. Well, anyway, that's some basis for the sheriff who is involved in this lawsuit. The order continues. Plaintiffs John and Tiffany, individually and on behalf of their minor children, have filed an amended complaint against defendants, the sheriff and his deputies, and social workers Rhonda Cash, Gina Kramer, protective service workers employed by the Arizona Department of Economic Security, is what it's called down there, like we have DHS here in Iowa. Also involved is the Administration for Children, Youth and Services. We have CFI up here. I'm guessing it's similar. Child Protection Services. And then there's Julie Rhodes, an Assistant Attorney General for the state of Arizona at the time of the alleged events. She's part of the lawsuit in federal court. Plaintiffs assert claims for constitutional violations that allegedly occurred during a home investigative visit following an anonymous complaint of child neglect. Plaintiffs have asserted a claim for violation of their Fourth Amendment right to be secure from unreasonable searches against defendant caseworker Rhonda Cash. So Cash and Kramer and 4 deputies are charged in violation of plaintiff's liberty, interest, and family privacy and integrity guaranteed by the 14th Amendment's Due Process Clause, based on threats to place the children into custody without cause, as against defendant caseworkers Cash and the remaining defendants have filed an amended answer to the amended complaint. Now, I just mentioned the 14th Amendment. DHS is not hiding behind it. They said they down below will find out that they're above the law. They don't think the 14th Amendment applies. Kramer and Rhodes failed to provide adequate training against defendant the sheriff. That's another claim. The social workers have filed an amended motion to dismiss. In other words, they've all filed motions to dismiss the case, hoping to get out from under this. I will say the bottom line is the court denied their request, so it's moving forward to a hearing. The paper order goes on and says, a motion to dismiss pursuant to Rule 12 tests the legal sufficiency of a claim. A claim may be dismissed only if it appears beyond doubt that the plaintiff can prove no set of facts in support of his claim which could entitle him to relief. In deciding on a motion to dismiss, the court should accept all material allegations of the complaint as true, as well as all reasonable inferences that can be drawn from them. Number 2, plaintiff's amended complaint. Plaintiffs have asserted the following allegations in their amended complaint. In January 2005, Child Protective Services, CPS, in parentheses, received an anonymous tip that plaintiffs John and Tiffany's children were being neglected. The tip alleged that the parents' house was not habitable, it was not painted on the outside, and lacked doors, stairs, and adequate flooring, and it was inhabited with rodents. I wonder why, if a house is not painted, why that's child abuse. In modern art and things, well, of course they paint, but in some cases, uh, people think it's nice to have the old wood without paint. Here, DHS criticizes the opposite. On or about January 29, 2005, at 12:30 p.m., CPIS agent Brenda Cage visited plaintiff's home in Phoenix and left her business card. Ms. Cage requested an appointment to discuss the anonymous tip but did not disclose the specific allegations. Plaintiffs declined to meet with her because they had not been provided with the allegations prior to the meeting. Plaintiffs alleged that they learned of the allegations regarding the habitability of their home on or about February 7, 2005. Plaintiffs allegedly had moved into the newly constructed house about a year earlier. Finished work remained to be completed, but the house had been approved by the county as habitable. Plaintiffs offered to provide CPS with a copy of the occupancy plan. Isn't that interesting? Now, one government agency, they have one piece of paper, and another government agency won't accept it, especially when it comes to parents here. On Wednesday, March 9th, approximately 10 a.m., defendants Cash and Kramer, that's the social workers, accompanied by two armed and uniformed sheriff's deputies, arrived at plaintiff's home. Now we're talking about two armed sheriff's deputies, and the story will get bigger as we go on. Defendant Cash indicated that they had a court order permitting them to remove the parents' children. Cash allegedly pulled out a piece of paper which she claimed was the court order. We've heard that before. The social worker says, "We have a court order." Well, produce it.
Right here.
Well, let us see it. Okay. The defendant Cash said, "I'd prefer not to remove the children. I just need to come in and look around." When the mother requested to see the order, defendant Cash refused. I wonder where she got so much cash. Of course, that's her last name, though. She probably has a fairly good job taking children out of the home. Defendant Cash refused, but stated she could not provide the order within 5 minutes. 5 minutes? I just saw John flash it in front of you, but I guess that wasn't the order. Plaintiffs allege that, based upon information and belief, defendants never obtained a court order allowing them to remove the children or search plaintiff's home. While the defendant's CPS agents and deputies were at the house, plaintiffs' members of the Homeschool Legal Defense Association telephoned that organization and spoke with attorney Thomas J. Schmidt. So they're talking on the phone at this point in time to the attorney in the Homeschool Association. So these are homeschooling parents. Mr. Schmidt requested the cellular phone numbers of the CPS agents. No, I mean the government, they don't want to provide anything. They want the parents to provide everything, especially the children. Mr. Schmidt spoke with one of the sheriff's deputies using plaintiff's telephone. The deputy acknowledged that plaintiffs had a right to be free from a search of their dwelling without a court order, but stated that if plaintiffs did not permit the search, he would obtain a court order. Well, I just thought the social worker waved a court order in front of him, but in reality, she did not. She just intimidated or made them try to believe that they had a court order.
See, that's what I was talking about a moment ago about regular procedures and then backdoor procedures. And it's difficult to build law to say that you must do it in a certain manner, but that's why we hire competent people to handle these things, not social workers.
Okay. The deputy handed the phone to Defendant Cash, who spoke with Mr. Schmidt and admon, uh, forcibly, it means, maintained that unless plaintiffs consented to the search, she had the authority to arrest plaintiff's parents and take the children into custody. Uh, what kind of an attitude is that, John? They not coerce, they intimidate, and
Well, they go far beyond their job description.
when in reality they didn't have the right to do it, but they try to make you feel like that they're all powerful and you better obey them. Especially when there's two deputies there ready to pull their guns and shoot. Well, you know that people get shot by these deputies. So if these deputies put fear into parents when they come to the door. Mr. Schmidt allegedly informed Defendant Cash that an anonymous tip was not sufficient to permit the search. So over the telephone, the attorney tells her what the law is. Now, she's not an attorney. She just thinks she knows everything. Defendant Cash, however, insisted that she be allowed to enter and search plaintiff's dwelling, citing certain Arizona statutes which purportedly allow a search without a court order, but allegedly misrepresenting the law. Defendant Cash and Kramer repeatedly asked the parents what they were hiding and told plaintiffs that the investigation would be dropped if they could determine that the allegations were false by searching the dwelling. These defendants informed Mr. Schmidt that they could arrest the plaintiff parents and remove the children from the home. Defendants Cash and Kramer further stated that if Mr. Schmidt continued to advise plaintiffs not to consent to the search, the plaintiffs would be handcuffed in front of their children and their children would be taken into custody. Mr. Schmidt related to plaintiffs his conversation with the sheriff's deputy and Defendant Cash and advised plaintiffs to allow defendants to see the children so they could verify that the children were in good health and were cared for. Plaintiffs brought their children to the front door so defendants could see them. However, defendants Kramer and Cash continued to insist on searching the house. It wasn't good enough to see the children are healthy. She had to search the house. Meanwhile, 2 to 4 additional, they weren't sure how many, additional police officers arrived at the scene. I'm sure they're carrying some more guns too. Defendant Cash suggested that Mr. Schmidt call her attorney, Defendant Julie Rhodes, at the state of Arizona Attorney General's office. So now the Attorney General's office gets involved here. Mr. Schmidt spoke with Defendant Rhodes, who allegedly advised him that Arizona gives CPS agents greater latitude to search a person's dwelling than that permitted by the Fourth Amendment when there was suspected child neglect. Let me interject that here in Iowa, you don't have to let a government worker, social worker, across the threshold without a court order. Well, we will find out as we go along whether Arizona has that law or if the DHS is correct that they're above the Constitution. Defendant Cash suggested that Schmidt call her attorney, and so he did. Mr. Schmidt spoke with Rhodes, who allegedly advised him that Arizona gives CPS agents greater latitude to search a person's dwelling than permitted by the Fourth Amendment when there was suspected child abuse. Defendant Rhodes allegedly stated that defendants Cash and Kramer, now she's there to protect, she's the attorney of record, so to speak, for the social workers. Defendant Rhodes allegedly stated that defendants Cash and Kramer did not need a search warrant or a court order to search plaintiff's home. All they need is the police officers there to intimidate you and try to talk you into opening your door. Believe a lie, and you'll fall for that lie too. And she goes on to say, the Fourth Amendment did not apply to CPS when investigating reported child abuse. Defendant Rhodes further stated that if plaintiffs did not permit the search, she continues to harass them here, the CPS agents could take temporary custody of the children under the Arizona statute. Mr. Schmidt allegedly advised Defendant Rhodes there was no necessity under that statute that would allow the CPS agents to remove the children. Plaintiffs allege that Defendant Rhodes then said that unless a search was permitted, she's still demanding a search. CPS agents would remove the children from the home. Mr. Schmidt relayed his conversation with Defendant Rhodes to the plaintiffs. Plaintiffs allege that defendants intended to arrest the parents and take the children into custody, and that faced with this threat, that's why parents feel like they're being threatened by the state of Iowa, by the guns these deputies carry. And we even had an article out of Colorado here a couple weeks ago where they came in with guns drawn, rifles drawn. They threw the parents and children to the floor, handcuffed them, and that's resulting in a lawsuit against those in authority or who think they're in authority. So there still are laws against this attitude by these people. The order goes on here. Plaintiff alleged that they permitted the search because of the coercion and threats of defendant Cash, Kramer, and Rhodes as backed by no fewer than 4 armed uniformed police officers, and because plaintiffs wanted to avoid having either themselves or their children taken into custody of defendants threatened. So the parents finally start to cave in here because of all these threats here. Pretty soon, if they don't cave in, well, you know, the deputies have all power to shoot you. So I'm sure the parents were very fearful here. The interaction at the front door lasted approximately 40 minutes, while the search of the home concluded in less than 5 minutes. Defendants Cash and Kramer told plaintiffs they found no evidence or abuse or neglect and that the case would be closed. Plaintiffs later received a letter to this effect dated April 26, 2005. So all this harassment, scaring the family all to death, there was no justification for it, and so the DHS closed their case. Okay, let me skim down through here. Let me change pages for sake of time.
This was about a 12-pager, I think, in federal court. It was an order arising from a motion to dismiss.
But the end result, the federal court did not dismiss it. It's moving on to trial. Okay, it goes on here. Plaintiffs do not allege in their amended complaint that they were in custody using these specific words, that the sheriff's deputies had their guns drawn, or that Miranda warnings were given. Plaintiffs do allege, however, that defendants represented that they had a court order allowing them to remove plaintiffs' children when they, in fact, did not have a order. They lied to the parents. How often does that happen? And then claimed that an order could be obtained in 5 minutes. Well, you either got one or you don't when you come to the door. Plaintiffs further allege that defendant Cash and Kramer told plaintiff's attorney that if they did not consent to the search, they would be arrested and their children would be taken into custody. Defendant Cash allegedly told plaintiff's attorney that plaintiff parents would be handcuffed in front of the children if he continued to advise them to refuse consent. Plaintiff further alleged that their attorney informed defendants that they had not pointed to any necessity to remove the children, but that defendants were still intent on removing them if plaintiffs did not allow the search. Having reviewed the facts alleged in this amended complaint in the light most favorable to plaintiffs, under plaintiff's version of the facts, defendant by threats and resistance coerced plaintiffs into consenting to the search of their home. plaintiffs have alleged sufficient facts on the face of the amended complaint which state a claim for relief based on violation of the Fourth Amendment as to defendants Cash and Kramer. The amended complaint, however, contains allegations that for approximately 40 minutes, defendant Cash and Kramer sought entry into the parents' home, despite the attempts by the plaintiff parents and their counsel to refuse such entry. As further alleged, defendants represented that they had a court order when they did not. Defendants allegedly threatened to arrest or handcuff plaintiff parents and remove or take the children into custody, backed by armed sheriff's deputies. These allegations are a sufficient basis for plaintiff's claim based on violation of the 14th Amendment. The court must determine whether a reasonable official would have been aware that the alleged conduct violated clearly established rights. Okay, Section 821 provides in relevant part as follows. A child may be taken into temporary custody by a peace officer or a child protective services worker if temporary custody is clearly necessary to protect the child because probable cause exists to believe that the child is either a victim, listen here, to see if the DHS here in Arizona were justified in taking the children. One, a victim or will imminently become a victim of abuse or neglect. Well, they had no proof on that at all, and there was no accusation that the children were being abused. Well, maybe there was an accusation. I'm not sure how you'd figure that. Just because you're living in a house that is not painted, you know, they need a place to live. They're fixing it up as they live in it. And the city had approved them and said that they had a right to live in the house. Number two, suffering serious physical, emotional injury that can only be diagnosed by a medical doctor. In other words, a DHS worker is not a medical doctor, so they can't take a child based on that reasoning. Three, physically injured as a result of living on premises where dangerous drugs or narcotic drugs are being manufactured. The children walked up to the door, and the DHS worker could see that they're okay. They acted like normal children, and yet that wasn't enough for them. A person who knowingly interferes with the taking of a child into temporary custody under this section is guilty of a Class D misdemeanor. That's a parent that's trying to protect their family at the door. Could be guilty of a Class D misdemeanor. My guess that could, for the most worst scenario, could mean a few days in jail. Maybe. But what's worse is to lose your children to the system and the system never return your children to you. I believe a parent has a right to protect their children. Okay, we'll go on here. Plaintiffs have alleged that defendant Rhodes was working with the other defendants to coerce plaintiffs into permitting a search of their home. This ruling is wrapping things up here, viewing the facts alleged in the amended complaint in the light most favorable to plaintiffs, to the parents in this case. Plaintiffs have sufficiently alleged that defendant Rhodes, by threat, exerted coercive pressure on them to allow the search of their home so that their children would not be removed. Plaintiffs have sufficiently alleged a claim of Fourth Amendment violation against Defendant Rhodes. Defendant Rhodes' motion to dismiss is denied, and the court denied other motions to dismiss, which means it will go to trial. John?
You mentioned several things in there are of some interest. One of them is the provision by which deputies could remove children, but the definition for that removal was so broad that would be subject to a lot of questions as far as I am concerned. Whenever they turn over bureaucratic authority to someone to disturb a family to that extent, then I think that all of the elements need to be in place. They need to put in all of the conditions, the general conditions that need to be in place for that removal, not just leave it up to their immediate fancy. Well, there's some things that we're going to be talking about.
One more comment, John.
Okay.
I'll refer to a couple case sites that maybe you've heard us say on the program here. It goes on to say the principle that government officials cannot coerce entry into people's houses without a search warrant or applicability of an established exception to the requirement of a search warrant is so well established that any reasonable officer would know it. That comes from Calabretta. That's a United States Supreme Court ruling that we mention from time to time. And then it goes on, the constitutional rights of parents and children to live together without government interference is well established, and that's found in Santosky versus Kramer. And I like to quote out of Santosky, the DHS has the power to create history. So when they knocked at the door, they started to create history in their favor. But at this point in time, it's been blocked because now there's going to be a federal hearing on it. John?
Okay, we wanted to talk. We've been talking about putting together just a little bit of a conversation regarding what happens when you hear the knock at the door, because this is a devastating situation, and we thought we'd talk about that as time permits. But for right now, we're going to listen to a gentleman who is very much in the area of reforming the courts, because until the courts are reformed, then any other efforts that we make in protecting children are for naught. Let's hear now from Terrance Walker.
Well, thanks again, John, for giving me that wonderful introduction like you always do. I just wanted to reflect a little bit on the Iowa judiciary and what's going on here in Iowa. So many times we talk about what's going on around the nation as it respects the judiciary, but let's talk about Iowa. Now in Iowa, if you could show the slide there, Donna. Iowa, we've got a system for removing judges. There's a number of different ways that you can remove a judge that have been set in place by the legislature here in Iowa, and this is similar to how it's laid forth in a lot of different states as well. There's basically 3 different processes to remove a judge. Number 1, judges can be removed by impeachment, and that impeachment involves not only getting signatures but also a majority of the House of Representatives and convicted by 2/3 of the Senate. The second way is a commission on judicial qualification. They can remove a judge, though they have rarely done so. I think 4 in the past 40 years or something to that effect. And then a retention vote. Every so often, depending on the rank of the judge or the level of the judge, it could be anywhere from 2 to 8 years. They'll come up for retention vote, and we as the people have the power to vote them out. We don't have the power to vote them in, unfortunately, here in this state, but we have the power to vote them out because the legislator has set in place what is called the Judicial Nominating Committee and the appointment system, the merit selection system for judges here in the state, whereby Judicial Nominating Commission gets all these recommended judges for the offices, the higher offices, especially like the Iowa Supreme Court and the Iowa Court of Appeals, and then the governor then appoints those judges. So um, that's how those judges are selected. We do have one other unspoken of way that a judge gets removed. One is by retirement. Uh, Judges are required to retire at the age of 72. They can still be senior judges and do part-time work, however. But we do have one Supreme Court judge, Judge Larson, who just turned 72, and he's going to retire. And so we have the Judicial Nominating Commission is going to select from a list of people that are nominated for the position, and then they're going to scale down those nominations to 3 people after they screen through them, and then the governor, Governor Culver, is going to select one of those. So be paying attention to that, because we do have the power to still influence that nominating process, and we can, if we have some history on the judges, or some knowledge of the judges directly or indirectly, we can still write to the Judicial Nominating Committee members who are on that website. I wanted to put that website up a little bit longer. I'm sorry, Don. Forgot to tell you. It's www.judicial.state.ia.us, and that website there, you can actually not only look at the processes a little bit more, but you can also look and see who the nominating commission is, when they're going to meet, when they plan on selecting the judges and the Supreme Court judge. And if you have some input, I would write to each individual member and specifically spell out what you like or dislike about the nominees. And also write to the governor, because he makes the final selection out of the 3 that they present to him. Also, I wanted to point out, when we're talking about the removal of judges, in the justice system, we do have a problem. I've talked about this countless times. We don't have really a good method of bringing accountability to the justice system as it pertains to judges, because the processes tend to not work. Again, I talked about how we've only had about 4 judges removed by the process of Judicial Qualifications Commission in the past 40 years here in Iowa. I don't think we've had any impeached for nearly 80 years. And then the retention vote, I don't think have we ever removed one? I don't think we've ever removed one here in Iowa. So when we're talking about accountability and making sure that the judges here in Iowa are, held in line.
We came close to one in Marshall County.
Yeah,
where the judge got 52%.
We did.
Vote.
And it was on hot button issue such as, what was it, gay marriage or something to that effect, or
no?
That
one was on a child abuse.
Child abuse allegation. There we go. Okay, gotcha.
Didn't we have one removed by a vote about less than 10 years ago, and the Bar Association was behind that. They didn't want to keep him in there, and he was here, I think, in Polk County.
Yeah, I think there was some other judge that I don't know if it had to do with abortion or gay rights. It was some hot button issue that they wanted to vote a judge out. This was the last term. I can't remember who exactly it was. But again, here we have another process, and I'm bringing this to light because we do have, and I think it's interesting. I don't want to talk about the gay marriage or any of the hot button issues, abortion or anything like that. That's another show. I really don't want to delve into that. My whole concern is the process, whether it's fair, whether it's working, and whether or not it's going to be stalled or anything. We do have a news item out of right here out of Des Moines, Iowa, whereby an activist, Bill Salier, he basically ran for the United States Senate in 2002. He's trying to oust a judge, Polk County Judge Robert Hansen, claiming he'd overstepped his authority in issuing a ruling in August of 2007. He's presented over 6,000 signatures calling for the impeachment of the judge, who struck down a ban on the state's gay on the ban on the gay marriage law, or there is no gay marriage law, so he struck down the ban. Well, he struck down the law, I should say. Anyway, Bill Salier is basically quoted. It says, "What we're driving for here is to stop a runaway judiciary. If the people in Iowa want to have gay marriage, they would elect a state house, a state legislature, and a governor who would reflect that. That's not the will of the people at this point. It's a matter of applying the proper amount of pressure to legislatures who may be squeamish. The next step is to let folks know in their district, know who's not doing their job. And this move is the latest in the political debate over Hansen's ruling, which is on appeal to the Iowa Supreme Court. The legislator would have to basically to ban gay marriage is what they would to do. They would have to basically approve the measure in 2 consecutive sessions, meaning the soonest it could appear on the ballot is 2009. And when asked, I guess, what the legislator is going to do about this impeachment proceeding, Speaker Pat Murphy out of Dubuque said, "We're not doing anything. We're going to continue focus on the things we talked about on the first day." Now, again, I don't want to get into the whole gay marriage thing. That's not I don't have any concern about that one way or the other. Like I said, what I'm concerned about is how a legislator who's presented with a petition for impeachment with signatures, enough of the required signatures to get the ball rolling, is saying that they're not going to do anything on it. And again, if you look at the numbers, there's been 4, maybe 5 judges removed in the past 80 years, and that's not to say anything is, I mean, we can't really say that the judges are that great. We can't say that they're that bad, but I mean, I've ran across enough of them to know that there's still some bad apples out there, and if we don't have a system of accountability that weeds them out, and the legislatures are not responding to properly filed documents, then we do have a serious problem here. And Pat Murphy says, "I'm not going to interrupt the judicial process, even if it involved the November election. We are focused on the mainstream issues most Iowans are concerned about." Well, I'm sorry, Pat, but if you've got 6,000 signatures, then I'm sure that is an issue that a lot of people are obviously concerned about. And it's so sad that it took a hot button issue such as gay marriage to bring this issue to the forefront, to the light. Because a lot of times you'll go to court and you'll see a judge skirt the law or ignore the law or basically rewrite the law, and nothing happens because it's not a major hot button issue, But it's good that this fact came to light, is that they did. I mean, that in this manner, it did come to light that this thing does happen. Now, that's not to say that the judge didn't issue a reasonable ruling. A matter of fact, Ben Stone of the Iowa Civil Liberties Union said that his ruling is based on perfectly reasonable legal interpretation of the Iowa Constitution. However, if you look at the petition that's drawn out by the Bill Salier, I think I got a copy of that. Do you have a copy of that on the
Citizens petition?
Yeah, on the citizens petition.
Yes, we got it up, ready to go.
All right, that citizens petition brings forth some very meaty issues there, and he states on this petition that ever since Iowa's founding, our legislature has declared marriage as a civil contract, and the long predating Iowa statute law says that common law also recognized marriages existing between a husband and wife. Iowa's long understood the marriage only occurred between a man and a woman. And He's got a long list of citations here, and again, my beef is not with that at all. Um, my beef is with the fact that a judge can basically rewrite law, and citizens evoke the process for bringing this into question, and the whole process is stalled. Now, this is a similar thing that I argue goes on with the Judicial Nominating Commission and our Judicial Qualifications Commission, which has removed, like I said, only about 4 judges the past 40 years since they've been in existence. So, I mean, if they can do that and the legislatures can get away with putting something on the back burner when it's properly presented and this process is properly evoked, invoked rather, then I think there's some serious problem. There is no method of accountability. That's why we need the judge of the judges here, because we're going to bring this to the forefront. And I think we should all put some heat on the legislatures and write to our legislators to act. I mean, because we've got to have accountability in the system. Like I was bringing up the analogy last week, if we're going to our favorite football game, whether it be the Iowa Hawkeyes, whether it be the New England Patriots, whether it be Green Bay Packers, if we're going to go watch our favorite football game, or if you're into hockey or whatever game you're going to, and you see something that is flagrantly a foul, and the referees miss it, and they miss it again, they miss it on purpose, and they make up their own rules, we would be very, 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 very offended, and we would be very upset, and I would imagine there would be a major uproar in the media about it, and you know, we would definitely not want that referee or umpire to be at that next game, or to be willing to, or be able to um, consistently be inconsistent. But when it comes to our property, our liberty, and our life as it reflects that matters in our court systems here, and we've got people that are consistently inconsistent, we have a system that we can't remove these officials. We can't remove them. We can't even fine them. We can't sanction them. We can't even replace them because the system of accountability is just not there. The legislatures are thumbing their nose at the whole process. The guy went through and got 6,000 signatures. Can you imagine? That's a lot of signatures. Can you imagine getting 6,000 signatures? Can you
a whole
imagine?
afternoon, wouldn't
It would take a lot more than that. And I definitely wouldn't want to go through that process, but I would if a judge would not be fair. Now, there's a number of different issues that you can actually claim on a petition to impeach a judge. You can claim that they deliberately, willfully, and wantonly exceeded their authority. They trampled upon the sovereign rights of the Iowa legislature and the people, and they ignored all controlling legal precedent, an attempt to strike from our state law uh, certain provisions, and what they what what the judge here is basically alleged to have done is ignored not only the law as it pertains to a definition of marriage, but also now, granted, I do think that it's when you look at a 63-page, I haven't seen it, but I'm saying if it was a 63-page ruling, I imagine there was some reasoning that was based on. However, I do think that if he did, in fact, then go after he struck the law, went and allowed people to proceed in a manner that was contrary to existing law, then I would say that there's some merit to the fact that he did exceed his authority and allowing people to go forward for the most part, because um, you've got to have the law in place before you can proceed. Now, Massachusetts, or I think one of the other states in the East Coast, what they did is they went and made a law allowing a civil union between a man and a man and a woman and woman, But that's something that the legislature did. They didn't do that at the judicial level. The legislature did that. So, like I said, there is some merit to his beef with the whole Judge Hanson thing. Um, but I just don't want to get into the whole thing gay marriage. But let's also wanted to read a little bit from his uh, his petition. Now, also in his petition to remove the, and you can look this up also. It's in Iowa Code Section 602.2201, and this is where the power to petition the legislature and to invoke the articles of impeachment. And I would definitely ask that you guys pay attention to that and pay attention to the process and put some heat on the legislature to do something about this, because I mean, if they're not going to do anything about we the people trying to use these methods that are set in place by the legislature to get them to act, then they're going to basically they're not going to act at all. And that's why we need real change as it pertains to the judiciary and the processes that the people can invoke. And I would urge whomever that has a problem with any judge that is acting out of line to not only bring it to our attention, but also, feel free to bring those issues to the legislature's attention, or to, you know, gather up some support, and in November, you know, whenever their term comes up for a retention vote, urge people to vote them out.
Yeah.
And we will,
Thumbs down.
give us a call, and we will definitely air your dispute with the judge or judges whom you have a problem with. But, I think we're running low on time, so I'm
Okay.
going to cut it short here. I think we got about 5 minutes left here, John.
You bet.
All right.
Okay. Well, thank you for that report. We need some of these judges. We need good, competent, well-meaning judges, and we certainly shouldn't have to tolerate those that are slovenly about their jobs, or those that are far too overactive, going outside the law. I said something about the knock at the door, and I have just a few words to say about that. We'll get back to this at another time. But DHS must send a parental notification mail that an investigation will commence. Now, of course, they're usually at the door before that letter gets to your house. But completion of the assessment is required within 20 business days of the beginning of that investigation. Another parental notification is made once the assessment has been completed. Now, that report doesn't automatically come back to you. You have to make a specific request to get that report in hand. Workers may make more than one attempt to contact the parent. Most often they'll leave a business card and ask that you contact the worker. One of the big problems here, too, is that they don't bother to let you know what it's all about. And I hate to meet with any bureaucrat who doesn't want to let you know what the subject matter is. And before you actually talk to them, they need to be debriefed as to what it is specifically that they have a complaint about. Now, they do not have to tell you who it was that raised the complaint, because this is all covered under all kinds of confidentiality rules. Alternatively, with the supervisor's permission, the worker can have confidential access to the child without the parent's consent. And I think that is a sad situation when that does indeed occur, because that means that they can go to the school, pull the child off into the audiovisual room, close the door. They can determine who is there and who isn't there. And so here's a child talking about a sensitive family matter with a stranger. And I don't think that is a good technique. And they're not required to videotape in situations like that. Okay, the worker can dictate who is present at the interview, and there's no requirement at present that the interview be recorded. See, at least it should be audio taped, or more preferably videotaped, and and the tape should never be permitted to be stopped, because we've heard of them taping a session and then stopping and telling the child what to say and then turning the tape recorder back on. That is not an adequate interview process in my way of thinking. There is no requirement that the worker specifically inform a 10-year-old or older child that he or she can choose not to speak, but that's in the law. You see, these laws are inadequate in their enforcement because they can say one thing and then the Department of Human Services can do whatever they please thereafter. So a 10-year-old can simply say, no, I'm not speaking to any social worker without my parents present. So if that word gets around largely enough, perhaps they'll stop pulling this, what they call confidential access at the schools. I think it would be an embarrassing situation to the children to discuss things of this sort with a stranger. And certainly the information that they gather, if it's not recorded, you have no way of knowing what the child said. And the children may not be able to relate accurately what it is that they told the worker. These workers quite often in their interviews with both parents and children come across as very charming, outgoing people. That is a report that we get talking to parents, that they are very smooth talkers. They get, they seem to be very charming, seem to be able to extract all kinds of information. You do not have to give them information. In fact, you don't even have to talk to them. It would be, however, wise on your part to give them sufficient information to match whatever they have in terms of accusation, so that they don't go away thinking that this person must be an abusive parent simply because the way they present themselves. Well, here's a couple of numbers that may be of use to you if you come across a problem with the Department of Human Services. We'll see you next week.